Good morning, everyone. We'll bring this meeting of the House Judiciary Committee to order, and we'll begin as we usually do with our Pledge of Allegiance. And perhaps Representative Kelly, could you lead us in the Pledge of Allegiance today? Sure you can. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. Representative Alden is filling in for Mr. Clerk, would you be willing to call the roll?
Representative Gordon.
Here.
Representative McLean.
Here.
Representative Sylvia. Here. Representative Welper is here. Representative Alexander. Here. Representative Green. Here. Representative Nodder.
Here.
Representative Murner.
Here.
Representative Kelly. Here. Representative Doucette.
Here.
Representative Andrus.
Here.
Representative Smith.
Here.
Representative Almy. Representative Horrigan.
Mr. Clerk, Representative Horrigan has had a little kerfluffle on the road. Representative Kenny has gone back to get him, and they're on their way, but they'll be a few minutes late.
Representative DiLorenzo.
Here.
Representative Chase.
Here.
Representative Langley.
Here.
Representative Macbeth.
Here.
Representative Page.
Here.
Representative Simpson.
Here.
We have 19 members.
Thank you, Mr. Clerk. And we do have two members who I understand are on their way. We'll begin this morning with House Bill 1073, which is our first item of business. It's an act repealing the right to know exemption for attorney-client work product. And Representative Wolper, do you have a motion?
Yes, Mr. Chairman, I would move ought to pass on House Bill 1073 with Amendment 0689.
Moved by Representative Wolper and seconded by Representative Sylvia that this be recommended as ought to pass with an amendment. And would you like to address your amendment?
Thank you, Mr. Chairman. Amendment 0689 simply adds a phrase after the existing attorney-client privilege or attorney work product doctrine exemption in the Right to Know Act. That phrase is consistent with the public's right to know. This may be redundant, but considering the history of this bill, this exemption, which came about last spring after the Supreme Court had issued a decision regarding this exact question of attorney work product privilege, it's my concern that the courts will now interpret this exemption without this qualification as being a total exemption for anything that an attorney does. Anything that could be considered attorney work product would be totally exempt from the public's right to know. Now, they shouldn't be doing that, because a lot of what attorneys do for us is not confidential in any great way. In fact, they actually work for the public. But without this clarification, and considering the timing of when this was introduced, I think this is a necessary clarification, and that's why I've added it.
Are there questions or comments?
if I could, Representative Wolper, just to get it on the record, basically the attorney-client privilege and work product are still exemptions from the right to know law, but with your amendment, this would qualify that so that a determination could be made as to whether or not whether the materials that were considered attorney-client privilege or work product are or should be made available because they are otherwise consistent with the right to know?
Yes, Mr. Chairman, it's my intent that the court recognize that we're within the Right to Know Act and that public does have a right to know, and that would modify their application of the attorney-client work product privileges.
And I guess if I could just follow up, so that effectively that means, since I'm not sure exactly how it would be interpreted, ultimately that would be interpreted by the court as to what that means?
Yes.
Any other comments or discussion? Yes, Representative Macbeth.
Thank you. So I respect the intent of the bill. It's concerning for me as a practicing attorney because it's critical that my clients can ask questions and share information on a broad spectrum of issues before I can provide them counsel. And some of the stuff they reveal is personal. Some of it might even, it's just in order to provide the proper advice. You really do need to have confidentiality, or perhaps people will omit things that are very important. Thank you.
Questions or comments? Seeing none, we have, and this is on the amendment. So this is a motion for adoption of Amendment 0689. And Representative Wolper, would you like to call the roll on that?
On the acceptance of Amendment 0689, Representative McLean.
Yes.
Representative Sylvia.
Yes.
Representative Clark votes yes. Representative Alexander.
Yes.
Representative Green.
Yes.
Representative Notter. Yes. Representative Murner.
Yes.
Representative Kelly. Yes. Representative Doucette.
Yes.
Representative Andrus.
Yes.
Representative Smith.
Yes.
Representative Almy. Representative Horrigan is not here, I'm sorry. Representative DiLorenzo.
Yes.
Representative Chase.
Yes.
Representative Kenny is not here. Representative Langley.
Yes.
Representative Macbeth.
Yes.
Representative Page.
Yes.
Representative Simpson.
Yes.
Mr. Chairman,
Yes.
I have the vote at 19 to 0.
Is there any objection to and now we have a vote on the underlying bill. We now have before us a motion of ought to pass as amended. And is there any discussion on the underlying motion? Seeing none, Mr. Clerk, would you like to call the roll?
On ought to pass as amended, House Bill 1073 with Amendment 0689, Representative McLean.
Yes.
Representative Sylvia.
Yes.
Representative Walper votes yes. Representative Alexander.
Yes.
Representative Green.
Yes.
Representative Notter.
Yes.
Representative Murner.
Yes.
Representative Kelly.
Yes.
Representative Doucette.
Yes.
Representative Andrus.
Yes.
Representative Smith.
Yes.
Representative Almy.
Yes.
Representative DiLorenzo. Representative Chase.
No.
Representative Langley.
No.
Representative Macbeth.
No.
Representative Page.
No.
Representative Simpson.
No.
Mr. Chairman,
Yes.
1, 2, 3, 4, 5 from 19. I have it 14 in the affirmative, 5 in the negative.
Is there going to be a minority report?
So this will be on the regular calendar.
It'll be on the regular calendar. I'd note that
Minority.
Representative Woper will have, will write for the majority, and that Representative Macbeth will write for the minority.
That's ITL, Representative Macbeth. Thank you.
CACR 18, relating to reproductive medical decisions, providing that the state shall not infringe or unduly inconvenience the right of reproductive medical decisions. Is there a motion? Representative
Mr.
Notter.
Thank you, Mr. Chairman. I move ITL.
And is that seconded?
I'll second, Mr. Chair.
Seconded by Representative Green. And would you like to address your motion?
Well, we were all at the hearing, and there was talk about women's concern for health and safety, yet there was disdain for the use of an ultrasound, which didn't make any sense to me because perforation of the uterus is a risk when a woman gets an abortion. And we know from that's not safe. And I used to be a freelance writer, freelance journalist, and I've interviewed many, many people who prayed on the sidewalks. But that's another bill. But they told me they had firsthand accounts of seeing the ambulance come at night, where they take the women away at night. So where's the safety? Things still happen. And the bill's sponsor said she wanted to be on the right side of history. She said that more than once, and I just kept thinking about Abraham Lincoln and when he was asked, God's on our side, and he said, well, my greatest concern is not whether God is on our side. My greatest concern is to be on God's side. And I have a lot of notes on that one bill. I asked the abortionist about how many late-term abortions there. I think that's the other bill, though. So I guess it was all said in the hearing, and you were all there, so there's no need to keep talking about it.
Okay, other discussion? Yes, Representative Macbeth.
Thank you. So I appreciate my colleagues' comments. I won't be voting for the ITL. I feel that the New Hampshire people have spoken when they overwhelmingly passed the state constitutional amendment on privacy, and that this is needed just as a reinforcement regarding the right to everyone to exercise their conscious decision. I mean, their consciousness when making decisions of privacy regarding their spiritual, physical, and emotional health. So I'm sorry I won't be joining you on that, and I urge others to vote against the ITL.
Other discussion?
Mr. Chairman?
Yes, Representative Woper.
Mr. Chairman, in respect to the... Mr. Chairman, with the respect to the right to privacy that was enacted in our Constitution, that was a right to privacy of personal information. And it said nothing about the right to take the life of another person. So I don't believe that this at all comports with that constitutional amendment. And I don't believe the right to kill babies belongs in our Constitution.
Yes, Representative Smith.
I'm slow to get off the starting line on this. This is an issue over which reasonable, caring people may differ. And we come to this issue with very different perspectives. We come to this issue with very different understanding. But I think it is incredibly important that we recognize our obligation to respect those differences and be careful in what we say. We cannot assume that we know what others believe and why they believe it. and we can listen and we can respect. One very obvious issue here is that I don't know anybody who thinks abortions are absolutely terrific and we ought to, play tennis in the morning and then go have an abortion. I don't think that anybody feels that way. I also do not believe that anyone who believes an abortion in, whether it's before 16 weeks, which is all that Planned Parenthood would not perform an abortion after that, or 24 weeks, that we are committing murder. In each of those cases, Madam Chair, Mr. Chair, it's such a feminine issue, that's why I said that. We know that we are talking about a fetus that cannot survive outside of the woman's body. It cannot survive outside of the woman's body, so that until it reaches a certain stage of development, and at that stage of development there is no one under all but the most extreme circumstances who would agree to interrupt a pregnancy. To use words like murder, I think are effective if what you want to do is to play to the audience. I don't think they're effective if what you want to do is to deal with the facts and recognizing that a fetus that cannot survive outside of the woman cannot be considered separate from the woman and her life. I know in a bill that's coming up later, I deliberately put an amendment language that my very dear colleague, the clerk of this committee, proposed about 24 weeks, and I did that out of respect for him and his concerns, and I just hope that he in turn would respect the commitment and the intentions of those people who happen to see this issue differently. And I hope I didn't go on too long, but I think it's important to recognize that we are going to differ on this issue, and that's fine, but we should be differing, trying to deal only with facts. I'm not, for example, going to ask the earlier speaker to document where transportation has come in the middle of the night to take away bodies. I happen to think there's probably no justification for that. Maybe there is. I'm not going to question that. All I'm going to say is that I think we ought to try to just stick with the facts and not do anything more than that. Thank you, Mr. Chair.
Representative McLean. Representative McLean.
Thank you, Mr. Chair. So, constitutional amendments are very tricky things. The constitutional amendment that you referenced, Representative Macbeth, actually went through this House with multiple sessions, laboring over that language, and actually failed many times before we were at a place where we were very comfortable with it enough to send it off to the voters. And I think that the language in this particular constitutional amendment is incredibly, incredibly broad. And this committee recognized that in the last session where we had the CACR, and we rejected it largely for that reason. Now, the sponsors said that really we really think that Roe should be the floor. And we think that maybe we can go beyond Roe. But where do you go beyond Roe? Essentially, this constitutional amendment does leave that door wide open. There really hasn't been any discussion at all about where would that new ceiling be? So I really think, given the breadth of this amendment, in a post-Roe world, if that were to come to be, this is just not ready to go out to the voters at this point, and I think we as a committee would be wise to oppose it at this time. Thank you, Mr. Chair.
Other questions? Representative Almy.
Thank you, Mr. Chair. I'm just here as a substitute, but I wanted to make my own background on this known. My mother was one of very few women medical students during World War II. She rotated through what I would call abortion wards. They were abortion wards not of people that had come to get an abortion, but of people who had gone to a back door illegal abortionist and someone who did not have sufficient training. They were all dying of sepsis and things like that. You cannot stop abortions by outlawing them. You can only make them highly unsafe. And I myself spent 25 years working in third world countries, and I ran into a lot of doctors that essentially condemned women to death by telling them that they would not help them in any way. Usually it was contraception, that they would not let them have contraception. But I feel really strongly about this, that telling women that feel that they need abortions, that they cannot have an abortion, is in fact also could be considered murder. Thank you.
Thank you. Other questions and comments?
Mr. Chairman?
Yes.
Thank you, Mr. Chairman. Well, there's a big difference between demanding or commanding an outcome from a pregnancy and adopting a constitutional amendment. And I don't believe, especially considering the diversity of opinion within this committee and within our society on this issue, I certainly don't believe it's appropriate for a constitutional amendment.
Other questions or comments? I guess the only comment I'd have is the concern I have about the amendment. This is amending the Constitution, so this is something that we should take very seriously, obviously. It's not like a statutory change where if we
Could
don't
you bring
like...
the microphone closer, Mr. Chairman?
Yes.
Thank you.
It's not like a statute where we pass a statute one year and we don't like it, then we repeal it the next year. Then that can be done. And so this is a constitutional amendment, so I think we need to be concerned about that. My concern with this particular constitutional amendment is the language, because the language is very broad and subject, I think, to broad interpretation. We've all had this discussion about abortion today, but it doesn't mention abortion at all in the constitutional amendment. It talks about personal reproductive medical decisions. And the question is, how do you interpret that? What is that? Who's going to interpret that? And it's sort of like, if you're concerned about the Second Amendment, our arguments over what does it mean to bear arms. So I'm concerned about the language in it. I think the language should be, if we have a specific purpose in doing the amendment, the language should be more specific. That's my thought. Representative Macbeth.
Thank you. Just a brief comment, and you know how much I respect you, Chairman Gordon, as a jurist and as a chair of this committee. The word privacy is not in the United States Constitution, and we've done a pretty good job as the 250 years are gone. I mean, that's what our courts do, our government. I mean, we are an experiment, and we have been moving forward and refining what those initial principles meant for hundreds of years now, decades. And I really, reproductive medical decisions, that's not going to be very difficult, I do not think, to be defined. Unduly inconvenient. It's just as the last, amendment, what is privacy? And that, I think what's so important about this amendment is that it helps the courts define that, and it allows our citizens, which when we look at all of the polling that's coming in over the last, specifically the last, I think 15 years, our citizens are telling us more and more, we want this right. They're not saying we want a certain procedure. That's not what they're saying. They're saying we want the right to make this decision ourselves because it is so controversial, because they want it to be private, however they make the decision. That's how I see this, and that's why I'm asking my colleagues to really look at this. It's saying, yes, something that affects our bodies so significantly, our financial, our education, our lives forever, as far as whether we have a pregnancy or not, whether we have an abortion, whether we give up a child for adoption. All those things are such significant decisions that they are private, and that's how they should stay. So thank you for letting me speak, and I appreciate your comments as well.
Other questions or comments? Okay, we have a motion of inexpedient to legislate, and Mr. Clerk, seeing no further comment, would you like to take the roll?
On the motion of inexpedient to legislate CACR 18, Representative McLean.
Yes.
Representative Sylvia.
Yes.
Representative Welper votes yes. Representative Alexander.
Yes.
Representative Green.
Yes.
Representative Nodder.
Yes.
Representative Murner.
Yes.
Representative Kelly. Representative Doucette.
Yes.
Representative Andrus.
Yes.
Representative Smith.
No.
Representative Almy. No. Yes, thank you, I have that. Representative DiLorenzo.
No.
Representative Chase.
No.
Representative Langley.
No.
Representative Macbeth.
No.
Representative Page.
No.
Representative Simpson.
No.
Mr. Chairman.
Yes.
1, 2, 3, 4, 5, 6, 7, 8. What does that make it? 10 to. Must be 11 to 8. Yeah, you're right. 11 in the affirmative, 8 in the negative.
And a minority report?
Yes, I'll write the minority report. Representative Macbeth will write the maternity.
So we will,
Yes, Mr. Chairman, thank you. I would move on to pass on House Bill 1181 with Amendment 0744.
and is there a second to that? You second it? Moved by Representative Wolper and seconded by Representative Green, that this be ought to pass as amended, and you want to address your amendment?
Thank you, Mr. Chairman. So first of all, it's been understood, or although not widely recognized, that the mother's rights to control her pregnancy had to be balanced against other things. So the Supreme Court has explicitly expressed the idea that at some point in the pregnancy, the state has the right to interfere. In fact, it says their duty to interfere, to the point where we can have a ban, what we have in the Fetal Life Protection Act, after viability. What hasn't been specifically addressed in law is the father's rights. And it seems to me that naturally the father would have some right over his child and its life. So this is an attempt to encode that right, recognizing that that right is subordinate to the mother's right, subordinate to the state's right, but it's still a right that exists and should be part of the calculation of what happens. During the hearing on this bill, there were several objections that were raised. And this amendment addresses those objections, concerns. So one of the concerns was small thing, well, was about what happens if the jurisdictional question. What if one of the parents is out of state, or so the bill, this amendment clarifies that it has to be within the state of New Hampshire and it's only effective there. One of the concerns was the notification provisions, where it said the court would notify the respondent, right? Well, the courts don't notify respondents, so this amendment clarifies that it will be up to the plaintiff to notify the correspondent. One of the concerns was raised about the legal cost to the mother. This amendment addresses that. The father will now be responsible for all the legal costs of the mother. Another concern was postpartum care for the mother, and this amendment addresses that as well. The father will provide 6 weeks of postpartum medical care. So the only one that isn't addressed by the amendment per se was the question of how do you decide what kind of evidence is necessary for the father to prove his right is worthy of consideration, I think is the way to put that. And the answer is it's in the structure of the bill. Because the father has to attest, has to swear in his petition that he believes himself to be the father. Now there's only two ways that this can go forward. One is that the mother doesn't dispute, and the other is she does. If she does, the father can get DNA testing, which he has to pay for, which would prove positive whether or not he's the father. And if it doesn't, then it proves he's not, and there are we strengthen the fraudulent claim portion of this as well to penalize fraudulent claims. So we believe that all of the objections that were raised during the hearing have been addressed by this amendment, and makes it a strong bill that should go forward to identify in law that the father does have some rights.
Representative McLean.
Thank you, Mr. Chair. So I really support the concept of the bill. And I think that it is important that we recognize that the father has some kind of voice. And to totally take away that voice is something that is not right. And so the concept of the bill, I think, has merit. But when it comes to the standard, when you say the standard is really kind of laid out in the structure of the bill, in this legislation, is to maintain parity. It's to give the father some kind of voice and define what that should be. So I really think that, while this amendment goes away over the original bill, I would still recommend that we study this and get a better understanding of what exactly we think that voice should be. But to say the standard is tied up in the structure, I just don't think that has enough clarity for me. So I will be opposing the amendment.
Representative Alexander.
Thank you, Mr. Chair. I agree with Representative McLean. This clearly needs more study. My big concern is the what happens with the court. There's a lot of language in here saying that cases shall be heard within a certain time period, and that concerns me. I mean, there's a lot of timeliness needed in a situation like this, especially during a pregnancy, and then it goes up against our modest changes in the 6-month Fetal Life Protection Act that we just put in place, and how does that affect this legislation as well? So I think we need to study it more. The concept is okay, but I'm still a little apprehensive. I need to learn more. Thank you.
Other questions or comments? Yeah, Representative Chase?
Thank you, Mr. Chair. I agree with my two colleagues on this, that it really does need more study. I understand fathers should have rights too, but I also, unfortunately, have even had experience with my own ex-husband of the fathers. Sometimes they do it just because they want to get back at the wife, or I worry more about the child who then is going to be born and supposedly going to be taken care of by a dad who really is doing it for the wrong reasons. That frightens me, so that's why I would like to have it studied more. Find out how many fathers really have been denied. How many, I just don't feel there's enough check into the father's background of being a good parent to be able to bring this forward and let them make that decision and take a child. They could decide, "Ugh, it's too much work, I don't want to do this." And that's just how I feel about it. Thank you.
Other comments or questions? Representative Smith?
Thank you, Mr. Chair. I might have missed something in the amendment, and I would ask the sponsor of the amendment, knowing of his commitment to the product of reproduction here, I see nothing in this legislation or in your amendment that would indicate any continuing responsibility on the part of the putative father for the care and upbringing of the of what is now a baby functioning outside of the woman. So I don't see anything about food, clothing, or shelter of this product. I don't see anything about childcare, about access to health care, about any responsibility that any responsible parent should undertake if what we have done is interfered with a woman's right to control what happens in her own body, and there is now a product of that relationship that may or may not actually be the relationship. And there's no indication that there's anything that we care about. We don't seem to care in this about the baby. We only care about the right of someone who brings himself forward to say he's the father. And so that's my concern. What happens if there is no abortion, and then where are we? And I would hope, knowing that the sponsor is a caring, thoughtful individual, that he would want to go back to the drawing board to recognize a lifelong obligation to the product of this decision. Thank you.
Other comments or questions? Representative Chase, did you want to speak again?
Thank you. I just wanted to clarify when I was saying my ex-husband, I didn't have an abortion. We have 2 children together who he fought to take care of and never did. And I was constantly taking him to court for child support, for helping. So that's what I'm saying. Here's a guy who fought, saying he's going to take care of these kids, and he never stepped up to the plate. That's my fear. It's very hard to raise a child when they're wondering what happened to their dad. Thank you.
Representative Wolper?
Thank you, Mr. Chairman. And I appreciate the thoughtful responses and concerns that have been raised. And I'd like to start at the back and go back to the front. The concern about the well-being of the child after it's born. The father petitions the court to become the father in order, according to the bill, in order that he may have and raise the child. Once that child is born, the father has sworn in his petition that he is the father and he wants to raise and care for the child. We have a plethora of laws that deal with fathers' responsibilities to born children. That does not need to be part of this bill. That isn't the purpose of this bill, and there's no reason why it would be, because they already exist. So there's that. As far as the other concerns that are there, some of these are difficult to struggle with. I agree. How does the court decide when a minority right should trump the more significant right, if I want to call it that, of the mother? That's a hard call to make. I don't know how you encode that into any kind of law. That's a judgment call that would have to be made on a case basis. So I don't see that as a reason for not going forward with this. And with that, Mr. Chairman, I'll just say I'll call the roll.
No, actually, I think we should give other people an opportunity to talk. Yeah. Representative Simpson?
Thank you, Mr. Chair. I think we're getting at my question, but my question was specifically why under fraudulent claims it does say that the man would be required to pay monthly child support until the child has obtained the age of 18 years, but it's not mirrored. If there is an injunction, that same language is not mirrored. So if there's an injunction, the requirement to pay monthly child support is not also required. And I do understand. Thank you. You answered part of my question, Representative Welper, which is the law does already deal with that. Excuse me. I haven't talked much yet this morning. The law does already deal with that, and my feeling is that there should be a higher standard for a father who puts a mother in through this whole process. There might be a higher standard to their responsibility to the child. Thank you.
Okay, other questions or comments? Representative Almy.
Thank you. Maybe this is covered, but I'm not seeing it on, assuming that you're talking about a ex-boyfriend that has ill intent, could they make this claim just before the woman is about to have an abortion, and at that point, because she had been delaying it, trying to avoid what she thought is the necessity, trigger the 24-week ban by the time all of this stuff has been finished, even if he wasn't the father?
Do you want to answer that question, Representative Wolper?
Thank you, Mr. Chairman. Yeah, so the bill says that the whole thing has to proceed in such a way that we don't violate the existing law of 24 weeks. So if the woman's close to that and then petition comes forward, I'm pretty confident the court would just say, we can't deal with this in the time before we would be violating the law, and according to this bill, we can't deal with it. But they have that, right?
Thank you. I couldn't find it, but I'm not a lawyer.
Anyone else want to comment? I guess my thought on it was, as far as the amendment is concerned, the amendment probably improves what was originally presented, and I really wouldn't have any problem voting for the amendment itself. And the other part of it is I think I agree that in some respects the male portion should have a voice of some type, but it's the mechanics that are the problem here. You know, how do you make that happen? And I just don't think at this point in time this bill is ready with regard to properly forming the mechanics of giving that person the voice. And I think it would require a little bit of, but I think it's something that we should study and we should look at and make sure that we come up with the right product. Anybody else? So we have a motion. This is a motion on the amendment, Amendment 0744. And Mr. Clerk, you now can call the roll.
Thank you, Mr. Chairman. On the adoption of Amendment 0744 to House Bill 81, Representative McLean,
Yes on the amendment, but I will be voting no on the bill.
Representative Sylvia. Yes. Representative Walper votes yes. Representative Alexander.
Yes.
Representative Green.
Yes.
Representative Nodder.
Yes.
Representative Murner.
Yes.
Representative Kelly. Representative Doucette.
Yes.
Representative Andrus.
Yes.
Representative Smith.
No.
Representative Almy.
No.
Representative Horrigan. I'm sorry. Representative Di Lorenzo.
No.
Representative Chase.
Yes.
Representative Langley. Representative Macbeth. Representative Page.
No.
Representative Simpson.
No.
Mr. Chairman.
Yes.
1, 2, 3, 4, 5, 6, 7. So I have it, we got 19, 12 to 7? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10,
Yes.
11, 12 to 7. 12 in the affirmative and 7 in the negative.
So we've adopted Amendment 0744. Now we would be voting on the underlying bill as amended. Comments with regard to the underlying bill? Again, I shared the concern that was expressed by my vice chair, Representative McLean, and that is, I think the amendment is an improvement, but I think this requires more study and would vote against the ought to pass and hope an alternative motion would be made after that. Anyone else wish to comment? Or? Seeing none, you can call the roll.
On House Bill 1181, ought to pass with Amendment 744. Representative McLean.
No.
Representative Sylvia.
Yes.
Representative Walper votes yes. Representative Alexander.
No.
Representative Green.
Yes.
Representative Nodder.
Yes.
Representative Murner.
Yes.
Representative Kelly.
Yes.
Representative Doucette.
Yes.
Representative Andrus.
No.
Representative Smith.
No.
Representative Almy. Representative Di Lorenzo.
No.
Representative Chase.
No.
Representative Kenny, no. Representative Langley.
No.
Representative Macbeth.
No.
Representative Page.
No.
Representative Simpson.
No.
Mr. Chairman.
No.
1, 2, 3, 4, 5, 6. So I have it 7 in the affirmative, 12 in the negative.
The motion of ought to pass as amended has been defeated. Representative Wolpe, would you like to make an alternative motion?
I will. So, Mr. Chairman, I would like to move interim study.
I'll second that motion.
Any further discussion? Seeing none, you can call the roll.
On House Bill 1181 to interim study, Representative McLean.
Yes.
Representative Sylvia.
Yes.
Clerk votes yes. Representative Alexander.
Yes.
Representative Green.
Yes.
Representative Nodder.
Yes.
Representative Murner.
Yes.
Representative Kelly.
Yes.
Representative Doucette.
Yes.
Representative Andrus.
Yes.
Representative Smith.
Yes.
Representative Almy. Representative Di Lorenzo.
Yes.
Representative Chase.
Yes.
Representative Langley.
Yes.
Representative Macbeth.
No.
Representative Page.
Yes.
Representative Simpson,
Yes.
Mr. Chairman.
Yes.
So I have it 18 in the affirmative, 1 in the negative.
Do you want to do a minority report, Representative Macbeth?
Will
Is-
consent?
Yeah, is there any objection to it being on the consent calendar? No?
No objection?
No objection. I'm going to move on to the last bill, if I can, and that would be 1674, an act relative to reproductive rights.
Mr. Chair,
Yeah, Representative Alexander, would you like to make a motion?
I would, Mr. Chair, I'd like to move HB 1674 in expedient to legislate.
And is that seconded? Representative Wolfer, is that
Oh, I
seconded?
second.
Okay.
ITL?
Right,
Too
I know.
busy trying. You get ahead of me, I had other bills.
Thank you, Mr. Clerk, for doing that.
Do you want to address your motion?
Please, a lot of my concern lies in section 1 of the bill. It shall be public policy in New Hampshire that because it is vital to the equality and liberty of all individuals. We're forgetting the equality of liberty of the unborn in this legislation. This legislation also creates a separate right of action against the state for injunctive relief. Typically, I've in the past been opposed to adding new causes of action against the state. I think the existing laws would provide for relief. So for that reason, I just hope my colleagues follow me and vote in expedient to legislate. Thank you.
Representative Simpson, did you?
Yeah. Yes, please. Thank you. Thank you, Mr. Chair. I'll be voting against the ITL on this bill. I'd just like to say that multiple generations of women and girls have had access to safe legal abortion since Roe v. Wade was decided 49 years ago. It's highly likely that Roe v. Wade will be overturned by the Supreme Court this year. If that happens, the rights of women and girls in New Hampshire will no longer be protected federally. This bill would ensure what already exists here in New Hampshire, access to safe legal abortions for women and girls, up until the current ban in statute at 24 weeks. The new 24-week abortion ban is in statute, and we are asking, that the rights of women and girls be placed in law next to the restrictions. Thank you.
Okay, other questions, comments?
Mr. Chairman?
Yes, Representative Wolper.
So, the first question I have is reproductive rights. It seems to me that reproductive rights means the right to reproduce. Is that right?
Would you,
I mean,
Representative
so
Simpson, would you?
let me-
You-
I can make it easier.
I'm happy to
Right,
answer,
so-
but I'll wait
So
till
it seems to me that reproduction occurs at the time of conception. And after conception, we're no longer talking about reproductive rights. We're talking about some other kind of rights, like the rights to medical treatment or something, right? Which don't have actually anything to do with reproduction because it's already occurred.
Representative Simpson, would you like to respond to that?
Yes, I would. Thank you. Abortion care is a form of health care, and the reproductive system is a system that is part of all of us, but I'll speak for myself as a woman. The reproductive system and all that happens within it and belongs to it is includes the entire spectrum of care related to the reproductive system. So I don't think that rights to reproduction is only about the moment of conception.
Representative Wolper?
So, accepting that, if we enact this, would a child of, say, 13 have the right to reproduce. That would be, I would say, guaranteed.
I respectfully don't believe that that is a part of the bill. I'm not going to address that here. I'm happy to have that conversation with you afterwards, though, Representative Welper.
Other discussion? Yes, Representative Simpson.
I do want to say, on a somewhat related note, that this bill would make sure that if a 13-year-old were pregnant, that she would have access to abortion care under the law.
Representative Langley, did you have a question? No? Any other questions or comments? Seeing none, we have a motion of inexpedient to legislate. Representative Wolper, would you like to take the roll?
On the motion of House Bill 1674, inexpedient to legislate, Representative McLean,
Yes.
Representative Sylvia,
Yes.
Representative Walper votes yes. Representative Alexander.
Yes.
Representative Green. Yes. Representative Nodder.
Yes.
Representative Murner.
Yes.
Representative Kelly. Representative Doucette.
Yes.
Representative Andrus.
Yes.
Representative Smith. No. Representative Almy. Representative DiLorenzo.
No.
Representative Chase. No. Representative Kenny is not here. Representative Langley. No. Representative Macbeth. No. Representative Page.
No.
Representative Simpson.
No.
Mr. Chairman,
Yes.
I have it at 2, 4, 6, 8, 11 to 8. 2, 4, 6, I got 8.
Yep.
Is that right?
That's correct.
Okay. I've been 11 in the affirmative, 8 in the negative.
So we, on House Bill 1674, we've adopted the recommendation of inexpedient to legislate. Would there be a minority report?
Yes.
And that would be OTP? Ought to pass?
Yes.
I 15, whatever, phone call, conversation, find out if people can get here.
Yeah, my understanding is that they are nearby, maybe parking at this very moment, so why don't we recess until 20 past, and then we reconvene.
Okay, so we've done this one, this one. This one.
I did, didn't I?
Well, you looked over at me.
Oh,
Yeah. Maybe I didn't hear it, but
I thought I seconded.
Yeah.
Did I? Did I not?
I marked
Wh-
it down as seconding it, so he's gonna take care of it.
Okay, all
Yeah,
right.
no.
I screwed up.
Oh, that's all right. That's all right. Yeah, no problem.
We'll call the House Judiciary Committee back to order. And welcome our two members who were unable to be here earlier. And the clerk can note that they are now in attendance. Well, the next item of business is House Bill 1477. And is there a motion? This is an act prohibiting abortions after detection of fetal heartbeat. Is there a motion? Representative Langley?
Thank you, Mr. Chair. I would move inexpedient to legislate on House Bill 1477.
And is there a second? Seconded by Representative Chase. And Representative Langley, do you want to address your motion?
Not to belabor other points that have been made this morning up to this point in terms of abortion, but I would direct people to line number 9 in the document, and it talks about the unborn human individual, and line number 10 says from fertilization until live birth. I think if we implemented this law, that it would undo the ban that we currently have on the 24-week abortion and bring it from the date of conception on. The other comment that I would make is in terms of a heartbeat, there's a lot of electronic responses that can be picked up from a person's cardiology from at any point in their life, and that could easily be misconstrued as a viable heart. Thank you.
Other questions, comments? Representative McLean.
Thank you, Mr. Chair. I think that, you know, this legislation really does kind of go up against Roe, and but I'm going to support it anyway because I really think that this legislation is very timely because it's addressing the question of where we place value and how do we place value on the fetus and how does that value evolve. And, you know, if I could just kind of illustrate a point by not going back to Roe, but by going back to a different Supreme Court case 170 years ago when we looked at the Dred Scott decision. The Dred Scott decision was probably the most horrible decision that the Supreme Court ever brought forth, in which a black man who was living free, Dred Scott, was essentially put back into slavery. And you ask yourself, how could that happen? Were the people on the Supreme Court just not smart? How could that have happened? And the reason it was able to happen really is not that they were dumb, but it's where they placed value. And they did not place value on Dred Scott, a black man, the way that they placed value on a white man. He had value for sure, but more as property, like your Toyota Tacoma or something like that. Now you fast forward in time 170 years to where we are now, we go back, and for all the problems that we have in this country, there's nobody in this room, in this state house, in this state that would ever defend the Dred Scott decision. And the reason for that is that our understanding of our humanity has evolved, and we understand that regardless of our skin color, we are all equally human. Now we go back and we look at the Roe decision. Where did the Roe decision assign value? The Roe decision assigned value with the privacy of the woman, which I think is a great thing. You know, women should have privacy. And it also acknowledged that a woman has sovereignty over her own body, which is, again, something that I could really get behind and defend. And when it was put against a fetus, they said, well, maybe later on in the pregnancy, we have to have something, but we certainly don't want to subordinate these rights of women if all we're subordinating it to is essentially a bunch of cells. And if that was the case, I would be the #1 defender of Roe. but I don't think it is the case. And 50 years on, our understanding of the fetus has really evolved. And as our understanding has evolved and got much better with all this technology, our value, the value that we place on the fetus, has gone up and up and up. And it doesn't matter if the heartbeat at 7 weeks is a real heartbeat or it's just electrical impulses. What it's an indication of, and what we're understanding now, is it's an indication of an individual human entity. And so what happens is not that our value of a woman's privacy or sovereignty over her body has gone down, but just that our value of the fetus goes up and up and up the more we learn. So at this point in time where everything really is in flux, this bill, I think, is a very important bill for reassessing that value, and I think we should support it. Thank you, Mr. Chair.
Other questions or comments? Representative Horgan.
Thank you, Mr. Chair, and thank you for your patience. I apologize for being late, but what it says in the state constitution, the federal constitution, they talk about the inalienable rights that humans have. It's always from birth, and so our understanding, our knowledge about embryonic and fetal development is more than there was before. But the theory that they had back then was, in its broad outlines, pretty similar to what we have now. So I think the constitutional provision about birth still applies, especially given that a large percentage of pregnancies don't go to term anyway, even in the absence of deliberate abortion. So that's I think so. If we pass this law, that kind of muddies the waters a bit, because there's a definition of unborn human individual, which is from conception, and I understand why that's appealing to a lot of people, but that's inconsistent with what our Constitution and other law has said for centuries. So that's one reason why I'll be voting against this bill. Thanks.
Representative Chase.
Thank you, Mr. Chair. And I just wanted to address what Representative McLean was saying. You just mentioned about noises, basically, that it may be a heartbeat, may not be. This is about having a fetal heartbeat. How, are you just saying that when it's a bunch of cells and you can hear noise, you're considering that a heartbeat? I just want to make sure I was clear of what you were saying.
I'm saying that there was testimony in the public hearing that when they are detecting the fetal heartbeat, was it a fully formed heart? And I think that obviously it's not a fully formed heart, because at 6 weeks you can't survive outside of the womb. But it doesn't mean that it's not a heart, and it doesn't mean that there isn't something that is going on from an electromagnetical perspective, even if it's not a fully formed heart.
Representative Notter.
Thank you, Mr. Chairman, and thank you, Representative McLean, for what you said. I agree with you 100%. Dr. Seuss said, "A person is a person, no matter how small." And the word fetus is a Latin word that means little one. And you had mentioned slavery, which of course was a horrible thing, horrible thing, and we all know that now. And I think maybe someday people in the future will look back to us in today's world and wonder how we ever could have supported abortion. So I know this bill is not going to pass, but I can't vote against it, so I support it.
Other questions or comments? Representative Almy.
Thank you. I was 26 when that passed. I grew up in the time when if you became of reproductive age and you were female, you were either highly constrained, couldn't. You had to always think, if I do something wrong, or I'll walk down the wrong street, go out at night, etc., I might end up Yes, with a child, but with a child that established what the next 18 years at least of my life was going to be, assuming that I survived the pregnancy. This is not just a matter of privacy, it's a matter of enslavement of women. And that's what it felt like in those days. And that's what you're trying to get it back to. And I think that there is, I know from the polling that this state does not agree with this bill. Maybe it would head in that direction. I hope I won't be alive at that point. Thank you.
Okay, Representative Alexander.
Thank you, Mr. Chair. Personally, when it comes to these issues, I don't really care what public polling says. This is really a personal moral issue to each and every individual. What I would say this is that at the end of life, when doctors determine when the end of life is, it is when the heartbeat stops. So I'm just asking we have the same, we treat life at the beginning when the heartbeat starts, that is when life begins, and the state has an obligation to protect life. So at the end of life, I'm asking we have the same application at the beginning. Thank you.
Other comments, questions? Representative Di Lorenzo.
Thank you, Mr. Chairman. I just have a comment that there's been a lot of talk throughout this country, throughout this state, about self-determination and against government mandates. If this bill were passed, then there would be a mandate prohibiting women from having abortions. And I think it's wrong. Thank you.
Thank you. Any other questions or comments? Representative Langley.
Thank you, Mr. Chair. I have just one final comment. And it goes beyond this particular bill. I think to some of the testimony that we've heard as we've gone along this session around vaccination and COVID and how people have responded to that. And I've listened as people have come in and they've been very articulate and very passionate about saying how they felt about their freedom being violated because there has been encouragement either to wear a mask or become vaccinated, etc., and that they needed to make their own choice. I just find it really exceptionally confusing when I think about right to life issues, abortion issues, and reproductive issues, that as a woman, I'm not able to make that decision in consultation with whoever's most significant in my life and my physician. Thank you.
Representative Wolper.
Thank you, Mr. Chairman. There's a lot to be said here, so I'd like to follow a couple different threads. The first one is where Representative McLean started, but I don't want to start where he did. I want to go back to the foundation of our country and the Declaration of Independence. This country was founded on the idea that we're endowed by our Creator with unalienable rights, and among those rights are the right to life. Life is not created by us. Life is created by our Creator. And that life is an unalienable right according to the Declaration of Independence. Unalienable. That means it cannot be separated from your own self. When it is and forever protected as an unalienable right. According to that, life began, and we know from embryology that life, human life, every life, begins at conception. Not at 6 weeks, not at 16 weeks or 24 weeks. It begins at conception. So if it's an unalienable right, and it begins at conception, it should be protected from conception. Now, it's true we don't know when that human life actually begins, in the sense that we don't have any way of identifying that life exists. right? As we've heard in our testimony, women don't know they're pregnant for weeks after the time that they become pregnant, but they are, and the life has been living within them for that period of time. The purpose of government is to secure our rights back to the Declaration of Independence. So why isn't it, I believe, it is the purpose of government to protect human life. When you get to Dred Scott, the Supreme Court said that class of people are not human and denied their inalienable right to life, denied their very humanity. When we come to Roe versus Wade, the Supreme Court said, we don't know what that thing in the womb is. And so we're going to say that a woman has the right to control that thing in her womb. She owns it. But now we do know. We do know. And as the Supreme Court said in Roe versus Wade, if we did know, that product of conception would be protected because it has the unalienable right to life. And we sit here today knowing and argue about, well, just because it's not a real heartbeat. Are you kidding me? We know what that is. That's a person. It can be nothing else. Every organism reproduces after its own kind. A woman does not bring forth a grapefruit or a sheep. She brings forth another human being. And it deserves the protection of its unalienable right. And with that, I'll just say that if we look at what we're doing in that light, then the regime that has allowed over 60 million babies to be killed, intentionally killed, that's what abortion is, intentional killing of its baby, allowed over 60 million human beings to be killed with no protection, is the greatest human rights violation of all time. And I'll be supporting the bill.
Representative Notter.
Thank you, Mr. Chairman. They knew what that thing was in the year 70 AD. In the teaching of the 12, I'm going to spell it, Didache. I pronounce it Didache, could be wrong. It says in chapter 2 that you shall not murder, you shall not procure an abortion.
Representative Green.
To add on what's already been said, just a couple things from my own perspective. About half a lifetime ago, my wife and I were trying to conceive, and we were not able to. And in all this discussion, there's this, from what we've heard today, from what we heard last week in Reps Hall, there's just virtually no discussion about the alternative of adoption. An adoption attorney told us 30 years ago that for every healthy infant available, there's 100 couples that want it. So we couldn't adopt. There were just too many obstacles. We couldn't do it. Now a lot of people are successful, and it's become easier over the years. When we did it was pre-internet, and now there's much more of a phenomenon of international adoption and all that. But back in the day, that's what we were up against. So that was the first thing that helped me evolve on this issue. And I think the second thing is, I just thinking to myself in recent years, we as a society, we need to answer the ultimate question: does that growing human being in a woman's body, does it have value? Either it does or it doesn't. And I'll close with that.
Any other comments? Representative DiLorenzo.
Thank you, Mr. Chairman. One of the former speakers here mentioned the inalienable rights in our Constitution. And he said life, liberty, and pursuit of happiness. So it's a three-part right. Liberty allows us to make decisions about our own bodies. The pursuit of happiness allows us to make decisions about our own bodies. Thank you, Mr. Chair.
Other questions or comments? Representative Simpson?
Thank you, Mr. Chair. And I'd just like to refer back to a comment from my colleague. And just to say, Representative Welper, if I may, how much I deeply respect your faith and your commitment to this issue, and would like to state that I myself have a deep faith in my Creator, and that is very important to me. But I would also like to speak for those whose faith may differ from mine, and who may differ from yours, and may have their own faith, that I think it's really important that we allow individuals, women who are pregnant, to make the decisions that they need to make based on the law that we have in statute, the decisions that they need to make based on their own religious life, their own faith, their own spiritual life, if they do have that or not. If they don't, that they are able to make decisions based on their own, weighing the own factors in their lives that are important to them and to their families and to their communities and to the people in their lives. Thank you.
Okay. Tim? Representative Horgan?
Thank you very much, Mr. Chair. And Representative Welper recently, he started with the idea, which he thought was universal, is that there is a creator, but that's not a universally shared opinion. And even if there was a creator, a being who's somehow similar to us human beings, we don't necessarily know what his, her, its, their agenda is. So it's pretty presumptuous to to just sort of assume that a creator would definitely take the position that the sponsors of these bills doing in the issue. And certainly every species produces a lot more conceives a lot more individuals than are actually born. The humans, we actually have one of the highest success rates, because most babies are born who are conceived. Most conceived embryos do eventually develop into a reasonably healthy human being. We're pretty rare in that regard. So anyway, just want to say whether or not there is a creator doesn't really have much to do with whether or not this bill is a good idea, and I believe it's a bad idea. So thanks.
Other questions or comments? It's been an excellent debate here, but it's a debate that not only happens here, it happens everywhere, with people having differences of opinion, honest differences of opinion. And I have great respect for my dear clerk next to me, who does all the work and I take all the credit. And for all sides of the argument. I guess the way I've tried to think about this, and it's putting together my good clerk's argument about when does life actually start. If it starts at conception, and you believe it starts at conception, and you believe it shouldn't be taken, then I'm not sure deciding that when it has an electrical pulse is the right time to decide whether it should be terminated. I think if you intellectually look at it, it shouldn't be terminated at all, as opposed to at that particular given time. So, and we've just passed this law that says that you can't have abortive services after 24 weeks, which has only been in effect less than 2 months at this point in time, which appears to be reasonable. And clearly we can pass reasonable restrictions on abortion. I'm not sure saying at 6 weeks is reasonable. If you believe, and I know you wouldn't believe, but if you do believe that women should have a reasonable choice at some point in time, I just think 6 weeks probably isn't that right time. And so I'm going to vote against the bill on that basis, and just want to let everybody know that. Any other comments or questions? Okay, Mr. Clerk, we have a motion of inexpedient to legislate on House Bill 1477.
On the motion of House Bill 1477, inexpedient to legislate, Representative McLean,
No.
Representative Sylvia,
No.
Representative Walper votes no. Representative Alexander.
No.
Representative Green. No. Representative Nodder.
No.
Representative Murner.
No.
Representative Kelly. No. Representative Doucette.
No.
Representative Andrus.
No.
Representative Smith.
Yes.
Representative Almy. Representative Horrigan.
Yes.
Representative Di Lorenzo.
Yes.
Representative Chase.
Yes.
Representative Kenny. Representative Langley.
Yes.
Representative Macbeth.
Yes.
Representative Page.
Yes.
Representative Simpson.
Yes.
Mr. Chairman,
Yes.
I have it 11 in the affirmative, 10 in the negative.
And the minority report, Representative McLean, you're going to do a minority report? Yes, sir. Maybe ought to pass? Yes. House Bill 1625, an act repealing the prohibiting on entering or remaining on a public way or sidewalk adjacent to a reproductive health care facility. And is there a motion? Representative Page.
Make a motion, ITL, please.
And is there a second? Seconded by Representative Smith. And Representative Page, you want to address your motion?
Yes, thank you, Mr. Chair. I think the current buffer zone we have in place satisfies constitutional muster, but let me back up and say that I certainly understand that the First Amendment freedom of speech is a protected right, certainly, and certainly when it relates to civil political discourse or opinions, but it's not an unfettered right, and it's not an unfettered right even when that speech is exercised on a sidewalk. We heard testimony regarding New Hampshire's law dealing with a buffer zone that, in my view, is the New Hampshire way. We heard how it was carefully crafted to respond to the Supreme Court's decision in McCollum, which had struck down portions of the Massachusetts law. Like many things from our southern neighbor, New Hampshire, we do a little bit better. And this bill has, our current buffer law, has the flexibility that responds to the Supreme Court. It's a flexible bill, a flexible law as it is in existence right now. It's certainly distinguishable from the McCollum case, which is what the current bill relies on. And yesterday we heard the governor even talk about how the New Hampshire way of responding flexibly to certain elements is an important value that we cherish here in New Hampshire, and the current law does that. And I also think that through the testimony we also heard some pretty compelling testimony from the doctors who talked about what impact folks who are on the sidewalks are saying to them as they enter a facility. And that Dr. Tolan in particular had mentioned that, in her view, all the women that had entered facilities had gone through different levels of analysis about what has to be a weighty decision. And in fact, more disturbing to them was after having gone through that, they entered the facility almost traumatized, and I believe she used that word. So they had thought about that decision. But in some, I think, like I said before, this bill, our current law, is flexible. It responds to McCollum. It was crafted with the notice of what the Supreme Court had said about the Massachusetts law. And for those reasons, I think it is what we've heard about as the New Hampshire way of doing things that are flexible, and that makes sense. That's why I urge folks to ITL the current bill.
Representative McLean.
Thank you, Mr. Chair. As you mentioned, Representative Page, the right to free speech is not completely unlimited. But if you are going to place restrictions on free speech, then you really have to demonstrate a compelling need to do so. There has to be a really good reason. And in the years, I think it was 2014, since this law was enacted, we have a dozen clinics, I believe, from the testimony, in this state that provide abortion services. Yet, in all that time, they have never taken advantage of this statute. And, you know, I've been in the committee long enough to see people from various reproductive health centers come in, and I would ask them the question. In fact, last year, you may recall, there was a 72-year-old woman who testified that she would be an escort, she would escort the woman into the clinic. And she was saying, oh, it's terrible the amount of abuse I get, and there's people over in the other buildings, and they're filming and things like that. So I asked the manager of that clinic why, in this situation, she hadn't taken advantage of the very powerful provisions of this law. And, you know, she says, well, we're still working out something with the local police. And to this day, there still has nothing been enacted. So I would argue that the compelling need in order to put these restrictions on speech just has not been demonstrated. And so based on that, I'm going to support the bill. Thank you.
Other questions, comments? Representative Notter.
Thank you, Mr. Chairman. And again, I agree with Representative McLean 100%. Also, this wouldn't be the first time, I mean, I know this bill isn't going to pass, but we did remove a law that was not enforced. That was, it used to be illegal to warm up your car in the morning. And we argued, like, well, if you have a baby, don't you want to warm up the car in the morning? You know, you're not supposed to put the jackets on the baby, but that's another issue. But we did repeal that because it didn't make any sense. It wasn't enforced. So this is another law that's not enforced, so why have it?
Representative Kenny.
Yeah, thank you, Mr. Chairman. So I fully understand that it has not been used. But attacks are on the rise across the country. Human nature is human nature, and New Hampshire is not immune to that potential. And it's a tool in the toolbox that if it is ever needed, it's there. If you own a house and it hasn't caught fire in 6 years, you don't throw out a fire extinguisher just because you haven't used it yet. You'll be very happy it's there if a fire does come. And I believe that having that in the toolbox is only going to be useful if we ever have a situation where granite staters need to be protected, despite what your beliefs are on reproductive justice. It has nothing to do with that. It has to do with keeping granite staters safe if that is ever necessary. Thank you.
Other Representative Horrigan.
Thank you very much. I was a member of the committee when we passed this bill through committee, and we did. Well, I was part of a small group. My contribution was fairly small. I would give a special the lion's share of credit to Representative Birch, who I hope is recovering well, and I hope is possibly watching us on YouTube. But we were very, as Representative Page correctly said, we were very well aware of the what was going on with the Massachusetts law, and we tried to tailor it to meet the objections that had overturned the Massachusetts law with the McCullen versus Coakley Supreme Court case. So we were well aware of that. So we did make a lot of tweaks. Not me so much, mostly Paul and some others who worked on it. But I was part of the subcommittee. The other thing is we There's certainly a right for them to express their opinion, but you aren't necessarily allowed to express your opinion exactly where you want to, and certainly if you're blocking the entrance to a healthcare facility, whether it's because you're opposed to abortion or vaccines or anywhere else, that's not a constitutional right there. You do, and so there's no constitutional rights to harass or impede. And also, it's often representing that's providing counseling to the potential patients who are coming to the clinic, and there's also no right to provide for unlicensed counselors to operate on the sidewalk. And there's certainly a lot of questions about how well they're trained, I know the escorts, by the way, have a pretty extensive training program, and they respect they respect the patient's privacy rights and so forth. So they have a pretty extensive program, and it's really unclear what the counselors are. But in any case, there is no legal or constitutional right to provide unlicensed counseling services on the sidewalk. So that's just a couple of perspectives. I want to add a couple more reasons why we should keep the law in place and kill this bill. Thanks.
Other questions, comments? Actually, Representative Sylvia.
Thank you, Mr. Chairman. And I'm reminded by the gentleman from Durham that this bill and keeping it in place, the law and keeping it in place, keeps the people divided. It keeps people from being close enough to talk to each other and have a civil conversation. And I'd rather have the civil conversation. So I'm going to oppose the ITL.
Representative Wolper.
Thank you, Mr. Chairman. First, I'd like to the representative from Durham said there's no law protecting unlicensed counseling on the street, which is quite true. However, there's a lot of different levels of counseling. Counsel is what's used for giving advice, which is more along the lines of what the people who are outside the clinic do than anything else. They inform and advise women of their options and encourage them to take advantage of the options available to them. And when we talk about freedom of speech and when it can be curtailed, there are certain attributes the Supreme Court uses to make these decisions. And one of them is the speech being curtailed content neutral, or is the curtailment content specific? And if it's content specific, that's not really an allowable reason for curtailing speech. In this situation, the speech is 100% content specific. If they don't care if you want to go out and talk about various civil rights or who won the football game on the sidewalk, that's just fine. You could stand out there and it wouldn't be a problem. It's because the speech that they're trying to prohibit would take away their customers. So this law provides protection for the private businesses that are in the business of killing babies. That's not tolerable to me. So I would vote against it just for that reason.
Representative Kenny.
Yeah, thank you. I just want to respond to the civil conversations because it is a great sentiment, but that is not every person there. Some do want to pray. I do know we got testimonies with people with good intentions, but it's a distance of 2 parking spaces, and if somebody wants to engage and seek advice, the civil conversation can happen. But everyone is not civil. That is just a fact, and I believe 2 parking spaces allows freedom of speech to still be totally present and allows someone to go to a medical procedure without being harassed, because it does happen, and we will be happy to have this tool in the toolbox if it's needed. Thank you.
Representative Almy?
I was going to say about the same thing, that what we're talking about is getting in someone's face and telling them things they don't want to hear.
Representative Chase?
Thank you. I think in this day and age, women are aware of what their choices are. I'm not saying they may be in depth of the amount of acknowledgement, but you know you can put a baby up for adoption. You know you can go through with a pregnancy, and you can also have the option of not having a pregnancy for the reasons that you have personally decided and talked to with the people you love. I understand the praying. I don't know how many people are really taken by listening to someone saying, no, come over here and talk to us about it. I know there are people that are on the fence, absolutely 100%. It's a terrible thing when you have to face it no matter what. It's not a pleasant procedure. It's not something that doesn't affect your life. It does. But I don't feel that they're being yelled at or being even, I don't know, maybe I don't want to sit and pray. That's my personal choice. It's your personal choice to be there. If I needed help or guidance, I can come over and see you. I just don't, I don't know. I don't, is the concept that pro-life people think that the people who are having abortions, the women don't understand I'm asking a question to you. Don't understand what their options are? What?
Okay.
Sorry.
Representative Wolper, would you volunteer to address that?
That's an excellent question. I'm really glad you asked it. Because first of all...
You need to speak into your microphone.
Because first of all, post-abortive women, by an enormous majority, report that if they had had any support at all, they would not have done their abortions. So one of the things that the counselors on the sidewalk do is they inform women that there is support for them that they did not know existed before. That's one of the biggest reasons that they save substantial number of lives every single year, because they just offer help and support to the pre-abortive woman.
Yes, Representative Smith.
Thank you, Mr. Chair. I've sat here and listened to deeply held views that are disparate one from another, and I know in this committee we have respected those views and we respect each other, and I chose not to add to the conversation, but I do have to respond to what my dear colleague just said. I have said before, and I will say again, that each of us is entitled to our own opinion. We are not entitled to our own facts. And I would suggest to the distinguished clerk of this committee that the statement that he just made is not accurate, it is not verifiable, and it doesn't do credit to him when he makes such moving personal statements without trying to bring in statements that are not verifiable. And I would hope that each one of us would refrain from that. There is nothing that any one of us on this committee, in this legislature, in this state or country or world can do to end abortions. Abortions have existed as long as procreation has existed. We are not going to end that. We might by providing adequate education to our children about how to avoid getting pregnant when it's not appropriate for them. Education would help. It might help if we had availability of contraception to again prevent pregnancies when it is not wanted or appropriate. All of those are probably more significant in avoiding abortion than us believing that we can pass a law or a rule or make a decision that is going to end abortion. That is not going to happen. And I would suggest that the differences in our views are valid and understandable. But please don't invent facts, don't use statements from one source or another that you yourself haven't verified. I have mentioned before, and I will mention again, the very first year I served on this Judiciary Committee in 1997, one of my colleagues who was then a very young man who I think had just finished college, or he might have been his senior year, announced that women, he said girls, that girls give up their, go to get an abortion because they can't fit into a prom dress. And I asked him if he could please give me the names and addresses of those women because I would like to speak with them. And of course, he could not. And I would suggest to you that your statement that says that most women who have had abortions regret that and had the abortion because they didn't know they had a choice, I suggest to you that that is not factually accurate, and I would hope that you would try not to use those kinds of statements because I don't think it does credit to your deeply held views. Thank you.
You have the opportunity to respond if you want. Okay. Any other questions, comments? The only thing I'd say is that, and I don't support the bill, and I've given it quite a bit of thought because ultimately I think that restrictions, particularly in public places, should not be something that should be taken lightly, and we shouldn't engage in general. But we have, and we do. We impose a restriction, for example, on our, as having been a town moderator for many years, we impose a buffer zone on entering the polls. And we do that because there are people who are adamant about their particular positions who would make an effort to encounter voters as they come to the polls. And we've indicated that we don't feel that those voters should have to run a gauntlet in order to come to vote and exercise what they have a right to do. And so it isn't as if we haven't in the past exercised buffer zones. There are other buffer zones too, which I don't need to go into a description. But ultimately the question comes down to this, and as it does, I think, for me with all legislation, because I use the Skip Bowie standard, who is an electrician in my town. He says, Ned, please don't vote for anything until you figure out if it's really needed. And right now, I don't think this is needed because I think it's working pretty well. And when I listen to the testimony that we had over in Representatives Hall, the question is, what would people do differently than they're doing right now? And I heard from a lot of very wonderful people who are out in front of the facilities that we're discussing, who are doing their very best to counsel people if they have the opportunity to communicate with people, to do those things. But the question is, what would they do differently? And I'm not sure that they would do anything differently. I mean, they're still going to be, as from what I could see, for the most part, courteous people doing their job. So, long and the short is, I think keeping a buffer to prevent unwanted communications makes sense to me, and I'm going to vote against the bill itself and for the ITL. Representative Alexander?
Sorry, Mr. Chair, one more thing. The question behind this is proponents for the repeal of this buffer zone would say it's unconstitutional. Advocates for the buffer zone would say we've never used it because for one reason or another. My question is let's see if it's used, let's file a lawsuit and let's have the courts determine whether this is constitutional or not. It's been struck down in other states, so I would say like until the buffer zone is used, there's really no need to repeal it at this point. Thank you.
Any other questions or comments? Mr. Clerk, you want to call the roll?
On the question of House Bill 1625 being inexpedient to legislate, Representative McLean,
No.
Representative Sylvia,
No.
Representative Walper votes no. Representative Alexander?
Yes.
Representative Green? No. Representative Nodder? No. Representative Murner?
No.
Representative Kelly? No. Representative Doucette?
No.
Representative Andrus?
No.
Representative Smith?
Yes.
Representative Almy? Representative Horrigan?
Yes.
Representative Di Lorenzo?
Yes.
Representative Chase?
Yes.
Representative Kenny?
Yes.
Representative Langley?
Yes.
Representative Macbeth?
Yes.
Representative Page? Yes. Representative Simpson?
Yes.
Mr. Chairman?
Yes.
2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. I have it at 12 in the affirmative, 9 in the negative.
We've adopted the recommendation of inexpedient to legislate. Representative Page, you need to do the majority report, and Representative McLean, will you do a minority report?
Yes.
House Bill 1673, an act relative to women's health, privacy, and repealing the Fetal Health Protection Act. Representative Wolper, would you like to make a motion?
Thank you, Mr. Chairman. I would move ought to pass as amended on House Bill 1673 with Amendment 0688H.
Oh, 0688?
Yes, 0688.
And is that seconded?
I can second it, Mr. Chair.
Seconded by Representative Alexander. Supposed to be you?
Yeah, that's okay. You got
it. Okay, and do you want to address your amendment?
Thank you, Mr. Chairman. Mr. Chairman, the Fetal Life Protection Act has only been in effect for a couple of months, but it's been under attack ever since the day it passed, or even before. The major objection that's been expressed about this act is the requirement for an ultrasound for all abortions, but even though the act is constructed in such a way that it looks like that, it doesn't do that, because but in any event, in order to obviate that objection, I offer this amendment, which specifically says in the same paragraph that imposes the ultrasound, this subdivision shall be construed to require the performance of an ultrasound only if the provider either knows that the fetus has a gestational age of 24 weeks or is conscious of a substantial risk that the fetus has a gestational age of 24 weeks. So, to add to the compromise that the Fetal Life Protection Act already is, this language clarifies that the major objection that's been expressed ever since it passed isn't valid, or it has no strength.
So as I understand it, this replaces the entire bill with the provision with regard to the ultrasound, is that correct?
It does replace the entire bill with this provision of the ultrasound, yes.
Questions or comments? Representative Alexander.
Thank you, Mr. Chair, and I appreciate Representative Welper for bringing forward this amendment. This addresses my major concern that I had regarding the ultrasound mandate in September. I would say that this goes a long way to clarify the mandate. It also in ultrasound, knowingly at least 24 weeks is not a transvaginal ultrasound. A standard medical procedure would be a typical belly rub, non-invasive. I appreciate you bringing forward this amendment, and it addresses concerns. I think it helps clarify and strengthen the Modest Fetal Life Protection Act. Thank you.
All right. Other questions or comments? I just want to say I would not support the original bill, which in effect repealed the Fetal Health Protection Act, but I believe that that act is subject to some qualification, and this being one of them, and would support your amendment, but would support other qualifications as well. So. Any other discussion? Seeing none, we'll take a vote on your amendment.
On the adoption of Amendment 0688H to House Bill 1673, Representative McLean.
Yes.
Representative Sylvia.
Yes.
Representative Welper votes yes. Representative Alexander.
Yes.
Representative Green.
Yes.
Representative Notter.
Yes.
Representative Murner.
Yes.
Representative Kelly. Yes. Oh, I get the wrong sheet. Representative Doucette.
Yes.
Representative Andrus.
Yes.
Representative Smith.
Yes.
Representative Almy. Representative Horrigan.
Yes.
Representative DiLorenzo.
Yes.
Representative Chase.
Yes.
Representative Kenny.
Yes.
Representative Langley.
Yes.
Representative Macbeth.
Yes.
Representative Page.
Yes.
Representative Simpson.
Yes.
Mr. Chairman,
Yes.
I have it 21 in the affirmative, 0 in the negative.
Okay, we have adopted Amendment 0688, and we are now open to further amendment. Representative Smith.
Thank you very much, Mr. Chair. I would like to move OTPA on Amendment 0730H.
And is that seconded? Representative Simpson seconds it. And would you like to address your amendment?
Thank you very much, Mr. Chair. I would. And I have to address my amendment by beginning first to say my heartfelt thank you to my colleague, the clerk of this committee. The clerk of the committee listened carefully to testimony that was difficult for all of us to sit through. And he did hear and come to understand the ambiguity, the perceived ambiguity in language having to do with the ultrasound. I believe that the language that was passed quite inappropriately and without any hearing and without any deliberation in the Finance Committee to add inappropriately to House Bill 2 language that had nothing to do with the budget, that language was very vague, and it was perfectly understandable that reading that language would cause anyone to believe that an ultrasound examination, including an intrauterine ultrasound examination, was going to be required for anyone in this state undergoing a legal abortion. Remember, none of this applies at all to illegal abortions that go on in back alleys. And my hope is that we do everything we can to eliminate those. Representative Welper's suggestion was, I thought, appropriate, and while left to my own device, I might not include the 24 weeks. The 24-week restriction is not unreasonable. At least one, and maybe all, I don't know because I haven't done all the research, but at least one of the major legal licensed entities that provide a whole range of services, only one of which is abortions, they do not provide abortions after 16 weeks. 16 weeks is roughly 4 months. So certainly 24 weeks is not inappropriate. And I thank the representative for his amendment. I was very happy to be able to vote for it. But I see that as a floor, not as a ceiling. There are a couple of other items that were included in House Bill 2 that I also think are deserving of elimination. They basically come down generally to my consistently held belief that the legislature has no business in the doctor's office, that these decisions should be made by the woman and those people who she chooses to involve, including the medical professionals and her family, her religious, whomever else. But if in fact we are going to involve ourselves in these issues, then I think we have to make sure that we recognize that we have to have some other limits. The first change that I want to include is one having to do with fetal anomalies incompatible with life. And I believe that that is something that we should acknowledge. It happens. It doesn't happen always. It doesn't happen universally. But when it does happen, it is an incredibly painful circumstance and difficult new reality for someone who is pregnant and who has looked forward to having a baby and everything that comes from that. I, of course, know that the most important thing that comes from pregnancies and babies is that they grow up and they marry and they produce grandchildren, and nothing is more important than grandchildren. So I believe in those pregnancies going on. But sometimes there are fetal anomalies. Those are not something that the legislature can decide. That is something that a medical professional can decide with whatever additional help they need. So I would like to add, and as is added in my amendment, line 10, except in the cases of a case of fetal anomalies incompatible with life. That's one change. The next change that I wanted to make was to include in line 29 not just the life of the pregnant woman, but also her health. So it reads the life or health of the pregnant woman whose life is endangered by, and then go on. And I think that health is a very important addition. And so there are two changes that I want to make. The next changes that I want to make in House Bill 2, where none of this belonged in the first place, is to remove the criminal penalties against healthcare providers and the civil penalties against healthcare providers. Healthcare providers are licensed by the state. There are standards that they must meet. There are provisions, whether they're setting the bones in my arm or my leg, or whether they're obstetricians are involved or gynecologists involved in delivering care for pregnant women. We are talking about people where we recognize the obligation of the state to license and the opportunity of the public, whether it be the patient or anyone else, to question the responsibility, the decisions that are made. All of that is already in law. To add criminal penalties having to do with whether or not, or having to do with how they function in cases dealing with pregnant women, I think creates a chilling environment. We have enough problems in this state, and we see it all over the state, not only in rural areas but also in urban areas, in attracting qualified, trained, licensed medical professionals to come and do their jobs. And we expect to hold them accountable to the standards that exist in this state. And I have no problem with that. What I do have a problem with is creating the appearance that somehow how they perform in this area differs from the standards that they are expected to perform in every other area of how they deliver responsible, reliable health care. So I have, in this amendment, done just those things. I have enthusiastically added Representative Welper's 24-week limitation, including the possibility of an ultrasound if that is necessary to determine the 24 weeks. But I have added fetal anomalies incompatible with life, not just a fetal anomaly, but a fetal anomaly incompatible with life to this. I have added the health of the mother, and I have said, let's not arbitrarily put in here a restriction, and I'm going to stop now because I saw the chair's body language and he wants me to stop. And I almost always, not always, but I almost always do what the chair wants me to do.
Representative McLean.
Thank you, Mr. Chair. I just had a question for Representative Smith, if that's okay?
Of course.
Okay. Well, thank you, Representative Smith, for taking my question. So I think fetal anomalies incompatible with life, in my mind, is something pretty well defined, and I can kind of get my head around it. But you also add an exception for health. And health is not, I think, very well defined. And so because of that, my concern is that it may erode some of the effectiveness of the bill. So did you give any thought to maybe expanding the definition of health, or are you aware of case law out there that basically has already kind of settled down on what that definition is? Thank you.
Thank you. I think it's a legitimate question. If you look, the sentence goes on, it doesn't say just health. It says, then whose life is endangered by physical disorder, physical illness, or physical injury, including, and then it goes on. So that I believe that language
Narrows.
narrows it down. Thank you very much, Representative
Representative
Welker.
McLean, do you like to follow up?
Thank you, Mr. Chair. So in your understanding then, by adding on some of the follow-on definitions that are in there, let's say a woman was to get pregnant, and as a result of that pregnancy, and I'm not a doctor, so maybe this happens or doesn't, she gets severe migraines, but the thinking is that maybe once we go past the pregnancy, those would not be a persistent thing, not something that would not endure past the pregnancy. Would that be considered health, or no? That would be something that this would, in your opinion, not be covered.
Fortunately, it's not my opinion that matters, because what I have stated all along is I am not a physician. I am not a doctor. I am not in that room with the patient. And it would be a medical professional who could say situation X may or may not have been caused by the pregnancy, but has been exacerbated by the pregnancy, cannot be cured or would not disappear unless the pregnancy ends. And that, to me, is a decision that should be made by medical professionals, not by legislators who have all kinds of skills, but no skill in this.
Thank you.
Representative Notter?
One quick comment. Thank you, Mr. Speaker, Mr. Chairman. The abortionists
Promoted again.
the abortionists in New Hampshire are not required to be licensed.
Any other questions or comments? Representative Horrigan.
Well, I attempted to answer the question about abortionists being licensed, but I guess I'll pass on that one. Obviously, it has to be done. We're talking here about physicians who are licensed, and I suppose there's other medical professionals who might be performing. Anyway, but what I was we're adding the phrase "or health" to the subparagraph 3 in line 28 through line 1 of the first page and line 2 of the second page, and there's existing language that's not in boldface because it's been there all along for those 2 long months since the bill took effect, which says when the continuation of pregnancy would create a serious risk of substantial and irreversible impairment of a major bodily function. It's defined in RSA 329.43 Roman numeral 5, and that's a fairly broad definition of a major bodily function. So pretty much any bodily function is defined as a bodily function. So I've no because that's in the bill. So there already is protection here, and this, I believe, is putting that phrase in is just strengthening it. And there is, we're already, we're not putting anything substantially new. We're just strengthening what's already there. And
Thank you.
So
other questions or comments? Okay, we're...
Mr. Chairman?
Yes.
Thank you, Mr. Chairman.
Representative Wolper.
So, I want to start with this repealing of penalties. We talked earlier in...
You need to talk into the microphone, I think, and move it closer.
We've spoken quite a bit today about the value of the life. And when we talk about the penalties that are included in this bill, that's why they're there. Because this is the only procedure we know of, as far as I know, it's the only one that exists, where it involves the intentional killing of a human. And in this case, an intentional killing of a human baby that could easily survive. So there's that. So I don't see, if we remove these penalties, we're devaluing that human life. So that would be my first objection. I agree with the representative from Durham that the qualifications following the words "or health" does narrow that exception. I don't think it narrows it enough for myself to support the bill anyway, but I have plenty of other reasons to not. What I really want to talk about is fetal anomalies incompatible with life, which I don't believe exist in today's medical technology. About 4 years ago, maybe 6 years ago, we had a bill similar to this in this committee, and we had a vice chair of that committee who was, what do I want to call it, very diligently opposed to any exceptions at all. And we spent quite a bit of time talking about fetal anomalies incompatible with life. At that time, the only one that could be identified was twin-to-twin transfusion syndrome. And the reason that no others could be identified is because other anomalies that we normally consider, or did consider even at that time, incompatible with life, were being cured by the technology that we have today. So today, if you have, and I'm not going to try and use the medical terms because I'm not that. So if you have a baby who's getting fluid in the brain and it's swelling and it would kill the baby, today they can go in and withdraw that fluid and that baby can proceed through its more normal course of pregnancy. If you have a baby with an open brain stem, they can go in, they can take the womb out, open the womb, perform surgery on that baby and close those openings, and the baby can continue. I'll go back to twin-to-twin transfusion transfer syndrome. For those that don't know, that consists of when there are two babies in the womb and they share the blood supply. So one baby gets more, one baby gets less. That's just the way it works. And that would be fatal to the one that gets less blood. Except, even at that time, and this is several years ago, at the Cleveland Clinic, the survival rate of both babies was over 20%. The survival rate of one was way over, not 80%. And I'm quite confident that their technology has improved in the years in between. So I don't believe there's actually any fetal anomaly that's incompatible with life. So I would ask the sponsor to identify one or two.
Thank you for the question. And I would say if there is no fetal anomaly, that, what's the language, incompatible with life, then that language doesn't matter. But since I have no way of knowing that, because I am not a physician, I am not a geneticist, I am not technically skilled in any of those decisions, I believe that that should be left for medical professionals. And I do know that that's where those decisions should be made. If we have the most wonderful medical system and there's never an opportunity for a fetal anomaly that cannot be corrected, so be it. That's fine. Then nobody can fall under this. But I think it's likely, Representative, that there are fetal anomalies. And I want to make sure that women and their families are protected in that situation.
Can you follow up?
So we already know that not all abortionists in our state are required to be licensed. But even beyond that, it's my understanding that typical medical practice, if a doctor performs an operation and the patient dies or there's death involved, that there's another autopsy to determine if, in fact, the diagnosis was accurate and what the doctor did was correct. How do we know that anybody who wants to violate the 24-week abortion ban couldn't just claim that there was some fetal anomaly incompatible with life, right? And that's what they'll put in the fetal anomaly incompatible with life. How do we know that there actually is such a thing in the case where the law is violated?
I guess I can't answer that question. I'm not going to go through, the looking glass with you and say, what if, what if, what if? We live in a world in which sometimes things happen that not one of us would tolerate or want or expect. What we're doing here is trying to pass reasonable legislation that in fact honors our commitment to law, to medical standards, to all kinds of behavioral limitations, and respects the right of a woman faced with a difficult situation to get the best professional guidance she can in making a decision. And do I think someone might be outside there right now, breaking into my car? Of course somebody might be. Can I control that? Well, no, but there are laws to make sure that if they're doing that and they get caught, they can be held responsible. And it's certainly the same thing holds true whether you're a bricklayer or an obstetrician or even a legislator. No, that's not true. We're exempt from so many things. I think, truthfully, I'm not going to answer any other questions because I'm afraid that the chair is really going to get annoyed with me, and I would never want that to happen.
So, last statement.
Representative Wolpert, you want to just follow up with the last
So,
statement?
what I get from that is that we have created an opportunity here for anyone who so desires to violate this bill with no accountability, because there's no check on whether or not the reason given is in fact true, and no penalty even if it is true. I mean, even if it's not true, which effectively makes this a useless piece of law. So I'll be voting against the amendment.
I'm surprised to hear that, Representative.
We don't need the comment. So, Representative McBath.
Thank you, Mr. Chairman. I'm shocked at the statements that I've been hearing that a couple of my colleagues have made, that there is the unauthorized, unlicensed practice of medicine going on in New Hampshire. And I'm not sure if they're talking about the dispensing of a morning after pill by someone that it's not, but to say that if that's occurring, I think that that's an issue for, I mean, if people are illegally practicing medicine, I think that those colleagues should bring that forward. And if not, that is really an outrageous claim, and I'm concerned about the misinformation that people that might be hearing and listening to this might think about New Hampshire and about our laws and the operation of this committee. If those comments keep being made without being challenged or asked, at least some other time, this might not be the right time, but I just think those are spreading of misinformation is wrong.
Thank you, Representative Almy.
Thank you. I think what your colleagues are saying is that they are not licensed specifically to do abortions, but they are obstetrics and gynecology licensed doctors. The law that was passed directly affects our ability to have gynecology and obstetrics doctors in this state. I am from Lebanon. Lebanon is the center of Dartmouth-Hitchcock. My father helped restart the medical school many years ago. They can, if they are told that if they are faced, well, let me go back a second. We have lost most of the OBG doctors outside of major medical centers in this state already. There are too few babies being born. They have had to consolidate into major centers. If a woman is having major trouble with her pregnancy, she gets bumped up from Berlin to Lebanon, or from Berlin to Concord, or someplace like that. If they are having a major problem and they land at the desks of the top OBGYN people in New Hampshire, which is what usually would happen when it's a major problem and urgent, that doctor is faced with, in some cases, very rare cases, but they are faced in their practice with, am I going to allow this woman to die, or am I going to do an abortion? And you try recruiting people to come and join the few OBGYN doctors we have in this state when that is hanging over them. What we're doing is making sure that women are not going to have adequate OBGYN care if we keep that on the books. Thank you.
Representative Nodder.
Thank you. It is true that in New Hampshire, there is no law that says that an abortionist has to be licensed. So maybe that somebody wants to put in a bill to fix that, to make sure that they're licensed. My second question is for Representative Wolper. Is everything that you were describing, like the worth of a person and what's an anomaly, whatever, does that fall under the category of eugenics?
Well, it does, it could. But in the context of this bill, I don't believe it does. Unless you say that Down syndrome, which is was being more or less successfully eliminated in various countries by the process of abortion, if you consider that to be a fetal anomaly incompatible with life, or for somehow or other falling outside the scope of this, then it would. But there you go.
Okay. Representative Horrigan.
Yes, well, maybe I don't need to beat this dead horse, but there are, the law does apply to anyone who does an abortion regardless of whether or not they're a licensed healthcare professional. But as others have pointed out, you definitely do need to be a licensed physician or an allied profession, and you do need to be certified. So it is illegal to practice medicine without a license. The best I know, and there isn't a specific. I'm pretty sure it probably is correct that there isn't a specific chapter of the RSA's about abortions, but that'd be subject for another. Was I going on too long? And also, yes. So anyway, neither the hospitals nor the smaller reproductive health facilities. I can be quite certain that none of them are having unlicensed professionals provide surgical services such as abortion or any services, that they're all properly licensed and certified, and it would be.
Okay. We've had a pretty good discussion. Are we ready to vote? Okay. This is on the amendment. This is on the amendment 0730, offered by Representative Smith. Mr. Clerk, do you want to call the roll?
On the acceptance of Amendment 0730 to House Bill 1673, Representative McLean.
No.
Representative Sylvia.
No.
Representative Walper votes no. Representative Alexander.
No.
Representative Green.
No.
Representative Nodder.
No.
Representative Murner.
No.
Representative Kelly. Representative Doucette.
No.
Representative Andrus.
No.
Representative Smith. Representative Almy. Representative Horrigan.
Yes.
Representative DiLorenzo.
Yes.
Representative Chase. Representative Kenny.
Yes.
Representative Langley. Representative Macbeth. Representative Page.
Yes.
Representative Simpson. Mr. Chairman,
Yes.
2, 4, 6, 8, I have 11 in the positive, and then, 10 in the negative.
You've adopted Amendment 0730. And is there any other discussion on the bill? We've had a pretty thorough discussion here. If not, you could call the roll. This is on the motion of ought to pass as amended on House Bill 1673 with Amendment 0688 and Amendment 0730.
So just a question, Mr. Chairman.
Yep.
Since Representative Smith and Simpson authored the sponsoring amendment, can we call this ought to pass as amended by them?
You can, and I definitely will have Representative Smith do the majority report on this. And have Representative Simpson do the PI if that should be necessary.
On the question of House Bill 1673, ought to pass as amended with Amendment 0730. Representative McLean.
No.
Representative Sylvia.
No.
Representative Walper votes no. Representative Alexander.
No.
Representative Green.
No.
Representative Nodder. No. Representative Murner.
No.
Representative Kelly. No. Representative Doucette.
No.
Representative Andrus.
No.
Representative Smith.
Yes.
Representative Almy.
Yes.
Representative Horrigan.
Yes.
Representative DiLorenzo.
Yes.
Representative Chase.
Yes.
Representative Kenny.
Yes.
Representative Langley.
Yes.
Representative Macbeth.
Yes.
Representative Page.
Yes.
Representative Simpson.
Yes.
Mr. Chairman,
Yes.
I have an 11 in the positive, 10 in the negative.
And Representative Wolper, would you
Yes.
like to do a minority report?
It would be, yes, sir. Yes, sir, Mr. Chairman.
And that would be ITL?
That would be ITL. No.
Oh, it would be
OTPA
OTPA, yeah.
with my amendment.
Okay, is there any other business that we need to address here today? I'd like to have everybody do their majority and minority reports by next Wednesday, if that would be okay. If I could get it by Wednesday. I had everybody do them very quickly the last time because I thought we'd get them all on the calendar, and of course, they didn't get in the calendar, so. But I think if I got them by Wednesday, we could have them done by, and submitted by the end of next week.
Do you have any word on when we're likely to be meeting again and where?
I heard the second week of March, but I don't have a specific date, and I suspect it will be back in Representatives Hall. But I don't know exactly. I heard perhaps around the 10th, but I don't know for sure. That's what I heard. In any event, thank you, everybody. You know, tough discussions today and tough bills today, but this is all the House bills that we've gotten out, and we did that very well, and appreciate everybody's cooperation. And now we should have, I have not received any Senate bills yet. So we definitely will have next week off and perhaps 2 weeks off at least before we meet again. And so enjoy it. Take care. Thank you, everybody.
One time. Hey, Diane. Have a wonderful holiday weekend.
Thank you. You too, Mark. It was nice seeing you. And I'm glad you're better. So glad.
Had enough talking about abortion.
It was nice to have Susan Almy here, huh?
Yeah, she was an asset.
Terrific.
I know, she was.
Really? Yeah, so